Good afternoon, everyone. My name is Jeremy Herman. I'm an employment lawyer with Samfiru, Tumarkin, LLP. It's great to be back with you guys. I've hosted many of these Q&A sessions, and it's always a great opportunity to answer employment law questions live. We get many important questions, and this is a free question and answer session. So please don't hold back. Ask whatever questions you might be thinking of regarding your workplace issues, regarding what your rights might be in the workplace, and I'll be happy to address as many questions as I can. Just by way of background, as you know, or as you might know, we have offices across the country. I'm located in Toronto, Ontario, and we have offices also in Ottawa, Ontario, and also in Vancouver, British Columbia, and Calgary, Alberta. So we are all over the country, and our goal is to help as many Canadians as we can with their workplace issues. What I usually like to do before we dive into questions is to start us off with an important topic, an important trending topic that is impacting Canadians with respect to their workplace issues. And so what I want to talk about today is Election Day. So in Ontario, we have a provincial election. It's the 44th general election, and it's today, February 27th. And we've been getting lots of questions from people about what their rights are as they pertain to voting. And the workplace. And so a few things to note. One is under Ontario's Election Act, employees who are qualified to vote have the right to vote, of course, and they can take up to 3 consecutive hours of work to vote on Election Day during voting hours. Okay. So the point of all of this is to allow employees to vote and to give them enough travel time between work and getting to the polling station. And also just to note that if you are eligible to vote, you must be Canadian, you must be at least 18, and you must be a resident of Ontario. So when does your employer not have to give you time off to vote? So the simple answer to that is your employer doesn't have to give you the time off to vote if you have 3 consecutive hours outside of your work schedule to vote. So in Ontario, we have polling hours from 9 a.m. to 9 p.m. in the Eastern time zone. So let's say you work 9 to 5. You're an employee who works 9 to 5 p.m. A lot of people, those are their working hours. In that case, your employer doesn't need to give you time off to vote because you have more than 3 hours to vote, right? You end work at 5 and you have until 9 p.m. to vote. And so you have 4 hours there that you can get to the polling station. Maybe another example just to bring this home. If you are an employee who, let's say, works 11 to 8 p.m., then your employer must give you time to vote, right? Because you do not have 3 consecutive hours to vote, because you don't have 3 consecutive hours before work, because you start at 11 and voting only opens at 9. And you don't have 3 consecutive hours after you end work, because you end work at 8 p.m. and the polling station is closed at 9 p.m. So that's only 1 hour, right? So in that case, your employer would have to give you time off to vote. For example, even though you end work at 8 p.m., your employer might say, okay, well, you can leave work at 6 p.m., right? And then you have till 9 p.m. to vote. So there's the 3 consecutive hours. And it's just important to note that generally the employer gets to select which hours you can take off to vote. So if you need that time off of work, the employer can dictate what those hours would be depending on business needs. And your employer, of course, cannot refuse this, right? If your employer has to give you the time off to vote and they refuse to do so, there are penalties for that under the Elections Act. And so usually this is not going to be an issue. Most employers are aware that it's Election Day and they have to give employees the time to go and vote if necessary. and you're not going to run into issues for most people. But for those of you who do, your employers could face penalties. And so you might want to raise that if you absolutely must, if your employer's not giving the time off that you need. Okay. So that is just by way of background, and important to note about what your rights are today on polling day, on election day rather, in Ontario. Okay, so with that topical issue, let us dive into questions. We have a lot of questions here, so I want to get started with them. So the first question is on Facebook from Shannon. I have a chronic illness that is well documented. I've been navigating very stressful processes my employer requires me to go through to request flexibility with a hybrid work policy. My request for a medical accommodation has been denied twice, as they've decided I do not need the accommodation. Not exactly a disability denial, but should I be seeking legal advice? Absolutely, you should be seeking legal advice. And this actually, it may not only be an employment issue, it might be a disability law issue. And we have very skilled disability lawyers as part of our team at Samfiru Tumarkin LLP. I'm an employment lawyer, of course, and this session is dedicated towards employment questions and answers. But absolutely contact our firm at help@employmentlawyer.ca. And you can also learn more about this, as you see on the screen, at disabilityrights.ca. You can find out more about what your rights might be from a disability perspective. From an employment perspective, I don't want to ignore the question. So from an employment perspective, your employer has a duty to accommodate you, right? Under the Human Rights Code, your employer has to accommodate you, and they have to accommodate you to a very high level, right? The point that they have to accommodate you to is the point of undue hardship. That is what the Human Rights Code says in Ontario. And like I said, that's a high level. So your employer has to do whatever they can to ensure that you're accommodated. It could be a hybrid work policy, depending on what the issue might be. It could be that you need to work from home some days, or it could be that you need to come late to work some days. It could be that you need assistance, physical assistance when you're at work. There are lots of accommodations that could be implemented, of course, depending on what your restrictions are. And typically the way to go about this is you have to provide a medical note or medical documentation. Sometimes it takes the form of an FAF, a functional abilities form, and many employers require you to complete this, or require you rather to send it to your doctor to complete. And it will go through what your restrictions are. Your doctor has the opportunity in that document to outline what the accommodations are that you need. And once received by your employer has a duty to implement those accommodations, like I said, up to the point of undue hardship. Some people ask, do I have to be accommodated in the same job? So the answer to that is yes. Your employer has to try to maintain your current position with the company and accommodate you in that position. If it is at the point of undue hardship, that the employer just cannot accommodate you in the position, it's not physically possible, or it's extremely difficult for the employer to have you work in the position that you always worked in, and also accommodate you at the same time, then in that case, your employer could look for different positions within the company that do meet your restrictions. But first and foremost, the employer must try to accommodate you within your current position. Okay, so Shannon, I hope that answers your question. Lots of good information there. If you have a follow-up, please feel free to post it in the chat. Okay, we have another question on YouTube. I had scheduled a vacation day, but ended up working on it with ample proof, but my employer refuses to give the vacation day back. There's no written policy on this in our HR guidebook. Is this allowed in Ontario? Okay, so good question, and you're absolutely correct that there are certain minimum laws with respect to vacation. in Ontario, according to the Employment Standards Act. And some have to do with vacation pay, and there's also laws that pertain to vacation time. So you have to be provided with vacation pay. You also have to be provided with vacation time. The minimum amounts are 2 weeks of vacation time or 4% vacation pay if you work for a company for less than 5 years. And then that goes up once you work for the company for more than 5 years to 3 weeks of vacation time and 6% vacation pay. Now, an employer can always implement more than what the minimum laws are. So like I said, the minimum laws are what they are. Your employer cannot breach that. But the employer can say that a given employee has right off the bat, even though they've been at the company for less than 5 years, they have 4 weeks of vacation, paid vacation, or they get 8% of vacation pay. That is something that the employer has the ability to do. And if that is your entitlement, then that is a greater benefit that your employer is providing you, greater than the minimum amount. And your employer has to adhere to that. And typically these would form, these greater benefits, if they exist, would be in a vacation policy. All right. If your employer breaches that policy, then you have rights to pursue legal action against the employer. Sometimes that comes in the form of a lawsuit with our assistance, and also it could be in the form of a complaint to the Ministry of Labor, and we can assist with that as well. So if you have any more questions about vacation time or pay, absolutely feel free to give us a call or arrange a consultation with us. I'd be happy to meet with you on this issue. It is vacation time and pay are both entitlements that you have under the Employment Standards Act, under our legislation in Ontario. Okay. We have a question on YouTube from P. Chan. My doctor asked for them to place me in a back office role due to my medical condition. My employer then asked me to apply for internal roles. I did apply for 95 roles and had no success. The employer then says that P. Chan will be terminated, and then they got a termination letter. And P. Chan fought that and got a 12-month temporary role. And then the company has taken the position that P. Chan has forfeited all severance. Okay. Seems to be a lot going on here, so I'll try to break it down. As we talked about, yes, your employer has a duty to accommodate you based on your medical conditions, as outlined by the documentation provided by your medical professionals. And at that point in time, if you do get another role, then you're going to work in that role, presuming it meets your accommodations, then there's no issue there. If you are then terminated from that position, then yes, you are entitled to severance pay. Any employee who's terminated in Ontario is entitled to severance pay, except for a few exceptions. And that severance pay is going to be based on a few factors. Those factors are your age, your length of service, your position with the company. It's definitely relevant how much money you were earning, and generally the availability of similar jobs in the marketplace that you held with the company. So that is how severance pay is calculated. And it looks different for every employee. Some employees will be entitled to more or less severance pay depending on their factors, their age, their length of service, their position, etc. Severance pay could be as much as 24 months of pay, and many employees in Ontario are entitled to 24 months of pay. A very good way for all of you to determine how much severance pay you're owed is by checking out our Pocket Employment Lawyer tool. You see it on the screen, pocketemploymentlawyer.ca. We have a severance pay calculator that is free and anonymous. You can use the tool as much as you like. And like I said, it's free. No one will know if you use the tool. And you can use it whether or not you've been terminated from your employment, or even if you haven't, and you just are curious how much severance pay you'd be entitled to, even though you haven't been terminated. But in the event that you are terminated, you want to know what your rights are. So check out that severance pay calculator. It will ask you basic questions such as what is your age and position, and how long did you work for the company? How much money did you earn there? And then the calculator will determine how much severance pay you are owed in the circumstances. So it's an amazing tool. Feel free to use it. Again, pocketemploymentlawyer.ca. So P-Chan, I hope that answers your question. If you are let go after this temporary role and the company says that you're not owed any severance pay, absolutely contact us and we will help you. We'll arrange a call. So don't feel that you need to wait. We could even arrange a call before you're let go. If you have a sense of when you might be let go and you want to figure out what your rights are, then just arrange a call as soon as possible and contact us at help@employmentlawyer.ca. Okay. We have a question on YouTube from Quizzy Produced. My employer placed me under unpaid leave without medical benefits. I've been with the employer for 8 years. The last 3 years have been on LTD. LTD closed my case when I couldn't find a new family doctor. Do I have a case? So another one of these situations where there's a quasi employment and disability issue at hand. So first of all, like I mentioned earlier in this session, if you weren't with us, I'll say it again. We have a very skilled team of disability lawyers, and those lawyers will arrange a call with you, and they will let you know whether you have a case from a disability standpoint. If you have been cut off from your LTD, then you very well might have a case. And so you should, first of all, check out what your rights might be, as you see on the screen, at disabilityrights.ca, and arrange a consultation with our disability law team. Okay, and they can help you in that regard. What I can say from an employment perspective, which is the focus of this session, is that if you are on LTD and we're still in the same position with the company at the same time, you weren't working, of course, but you weren't terminated yet from the company, then if your LTD ends and you're able to go back to work, then your employer should bring you back to work. And if you have accommodation needs, then your employer, as we've talked about in this session so far, has a duty to accommodate you up to the point of undue hardship. Now, what I see very frequently in a case like Quizzy Produced is where an employee will be on LTD or their LTD will end, and the employer will let them go, and the employer will claim that the employment has been frustrated. What that means is essentially that the employee can no longer work for the company, and it's simply as a result of their in this case, it would be simply as a result of their disability or their medical restrictions. Now, employers often jump the gun and they claim frustration when there isn't really frustration, meaning the employee likely could go back to work. There might be some accommodations needed, but they could go and return to the company and work in some capacity. So for a company to say that the employee cannot work any longer because they're just physically completely unable to work, that's often not the case. And if that happens to you, then you will be owed your severance pay, and you should absolutely contact us. I've helped many, many people in this situation where they were on LTD ends. The employer at some point says your employment is frustrated, and the employer either will give no severance pay or will give very minimum amounts, not the full entitlement that the employee has. And I have assisted employees in that situation with getting their full severance pay. So feel free to contact us. If you have any follow-up questions about this issue, then please post it in the chat. Okay, great questions today. I'm going to move on with questions in a minute, but just for anyone who's joining now, again, my name is Jeremy Herman. I am an employment lawyer at Samfiru Tumarkin LLP, and I'm answering as many questions as I can today about your employment rights. So if you have any workplace issues, if you're if you were terminated with severance pay or with cause, if you were terminated without severance pay, then just feel free to ask the question. I'd be happy to give you an idea of what your severance might look like given your particular circumstances. If you've been demoted, if you have been told that you're getting a pay cut, or if you are told that you have to work at a different job location or work different hours than what you're used to, or you're told that you can no longer work remotely and you've been working remotely for quite some time. These are all very important, relevant issues that I see on a daily basis as an employment lawyer. And I'm here right now to answer all of those sorts of questions. So please feel free to post the questions in the chat and I'll get to them. Okay, so let's move on. As I said, we have a question on YouTube from FNC. My employer is looking to enact a fine system if things aren't done. If you forget to do a certain weekly task or are caught not wearing the proper dress code, you're required to pay money, which goes to fund team events. Just wondering what the legality of this is. All right, that's an interesting question. So what this likely is a constructive dismissal. If there's a certain policy that you've agreed to that says that if you don't adhere to the policy, then there will be certain repercussions such as fines, perhaps that is something the employer can implement, but it's neither here nor there. I definitely would have to review that policy, this fine system, with a fine-tooth comb to determine whether there are any legal issues with it. It does sound fishy for sure. But what it certainly could be is what I referenced just moments ago, a constructive dismissal. Constructive dismissal is a situation where your employer is changing the terms of your employment in a significant way. And we see this in all different forms. So one example, as we have here, is the employer is reducing someone's pay, essentially. If they have to pay a fine, and presumably it's just coming off their paycheck. And that could be a constructive dismissal. It will depend on how substantial the amount is, how substantial the fine is, that is. And if it is a substantial decrease in pay, then that would be a termination of your employment. Your employer has not said you're terminated. You haven't received a termination letter. But with this kind of implementation, this change to what you're normally paid, if it is indeed substantial, then that would be a constructive dismissal. And that means essentially that you're entitled to your full severance pay like any other employee is who's let go. All right. And we deal with cases like that all the time. As I mentioned, it may not be a pay cut. It could be in the form of a different job position or different duties. So, you could be a manager and then your employer tells you, well, we can't employ you as a manager anymore. So you're getting a pay cut of $20,000. You earn $80,000. Now you earn $60,000. And you're not going to have the same position title. You won't be a manager anymore. You're not going to have any direct reports. So I have cases like that regularly. That is a termination. Again, your employer is not terminating you. They're demoting you and changing your pay. But that is certainly a termination. You could treat that as a termination and you can pursue your full severance pay. All right. So don't feel as though your employer can just implement whatever changes they want to the terms of your employment. You work for certain terms, right? You work a certain amount of hours, you work certain duties, etc., and you get paid for them. And if any of those things change, then that is potentially a legal issue. So feel free to contact us about that, and we will assist. Again, as you see on the screen, we have tons of resources on our website. Check out employmentlawyer.ca. Everything I'm talking about, we have articles and videos that talk about these issues. So if you want more information, if I haven't been able to address your question today, then feel free to A, arrange a consultation with us, and B, check out our website, and you'll find a plethora of information on all of this. Okay, we have a question on YouTube from Two Ninja. I'm in the interview process of a new job. When I looked at the organizational chart of the business and former employees on LinkedIn, I get the feeling that the company has an above average turnover. So that means people get terminated often, or they leave the company often. I'm prepared to work at this organization, but I would like to protect myself from being let go in a short period of time right after joining. Is it reasonable for an employee to negotiate a starting severance of a certain amount of months? Yes, you can absolutely do that. So we assist people not only with end of employment issues. Our firm very much also deals with starting employment, the issues that pertain to when someone begins a new job. And usually a key thing that we deal with in that regard is an employment contract. An employment contract is, of course, a document that is signed between you and your employer, and it will outline all the terms of your employment. And so we can absolutely arrange to review your employment contracts. A consultation will be necessary for that. And if there are revisions that we recommend, we will assist you with making those revisions and if necessary, negotiating with your employer about the revisions to the contract. And so, as Two Ninja said, yes, you can absolutely ask for a certain amount of severance pay in an employment contract. That's usually the form it would take. There's a termination section typically in an employment contract, and the termination section can outline exactly how much severance you will get in a certain scenario, often based on how long you've worked at the company. Okay, so absolutely, that's something that can be negotiated, and we do these kinds of consultations all the time. So please reach out at helpanemploymentlawyer.ca, and I would be happy to arrange a consultation with you, review the employment contract, and make some revisions with respect to the severance entitlement. Okay, we have a question from Philip on YouTube. Can you explain how setting percent works? If a change of terms benefits me, I accept it. Must I accept future change of terms? Okay, so I think what you're trying to get at, Philip, is that if you accept a certain change to the terms of your employment, are you deemed to be willing to accept all future changes? So let's say your employer, a great example of this that I see often in my practice is an employer lays off an employee. And what I mean by layoff is temporary layoff. So your employer is not actually letting you go. Instead, they are saying that you're going to be laid off for a certain amount of time temporarily. And sometimes employees agree to that. And then a year later, they come back to work and they get laid off again. And so at that second time around, are you deemed to have accepted all layoffs that might occur because you accepted a previous layoff and you didn't raise it as an issue? So the answer to that is it depends. You very likely might be in hot water there. Because if you set a certain precedent, Philip, that you accept changes to the terms of your employment, your employer will have an easier time from a legal perspective implementing changes to your employment. But it's not always that way. So it really does depend on the particular circumstances, what kind of change was implemented, what the second time around, what the change looks like. Sometimes there might be an issue for you, and sometimes it might be an issue for your employer, and they will not be able to implement those changes to your employment, and you will have a recourse in that regard, and you will be able to pursue your full severance if you are faced with changes that you don't consent to. Okay, so I hope this was helpful. This was a great session. It was filled with really good questions. And we're going to be back with you tomorrow at 10:30 a.m. Pacific time with my colleague Dan. So please join then, and he will answer any residual questions I didn't get to today. So thank you for joining us, and I'll be back with you soon. Take care.